some may do it another, but states have the right to be right. States have the right to be wrong, and we have a responsibility to recognize the constitutional framework of our country, which was created by sovereign states. Thank you, Mr. President.
Clerk will call the roll.
Mr. Alexander.
I'll be dispensed with.
Without objection.
And I would ask to be able to speak in morning business for up to 15 minutes.
Without objection.
Mr. President, we have an attempt to move and rush through the Senate an immigration bill before the American people can adjust or absorb what's in it. I think this is a very bad policy. The bill was introduced at 2 a.m. 8 days ago. It was set for markup in the committee today, and our diligent staff has been trying to read it and absorb it and is having a great deal of difficulty sifting through this complicated 850-page bill. It's now, because Senator Grassley, the ranking Republican on the committee, has put the bill over, asked it to put over for 1 week. Next week is a recess, so it will now come up 2 weeks to be presented and passed out of committee. And we had Monday a hearing. It was, I won't say it was a circus, but it was impossible to absorb all the information. 23 witnesses testified, one right after the other, 5 or so minutes each, and the senators that were here on Monday, not a lot, had 5 minutes of questioning, and not much was resolved. They didn't know what was in the bill either. They were just testifying about policy, basically. Nobody could explain exactly how the bill is going to work. And so people say, well, you should be able to handle a bill like that. You should be able to read an 800-page bill. And so I would just want to show why this is a pretty complicated process and why a piece of legislation like this has to be carefully read. And it's not easy to do so. So this is page 65 of the bill. And it deals with an issue I talked about yesterday. Secretary Napolitano had issued prosecutorial directive and guidances to their ICE officers so upsetting the ICE officers that they sued her and their director, Mr. Morton, in federal court, saying she's directing them not to follow plain U.S. law. And I brought it up in the hearing, and Chairman Leahy said, well, a lot of people file lawsuits, very few win. Well, yesterday, or day before yesterday, the federal judge basically ruled in favor of the officers and said a secretary of HHS has no authority to issue guidelines that counteract plain, mandatory federal law. That was so basically the secretary was saying, do not remove certain people from the country that current law says must be removed. She's refusing to do what the law of the United States says. And this is one of the reasons we have such a problem reforming and fixing immigration law, is because the American people have little or no confidence in the willingness of our officials to even follow present law, much less new law. So apparently they plan to fix this in the bill, so the Secretary has even more power. It's the legislation. We've already found maybe 200 references to waivers and discretion of the Secretary in how the bill would be carried out. But look at page 65. Subparagraph B here, capital B, waiver. Subparagraph little I. In general, the Secretary may waive the application of subparagraph A little I3 or any provision of Section 212A that is not listed in Clause 2I on behalf of an alien for humanitarian purposes to ensure family unity, or if such waiver is otherwise in the public interest. Any discretionary authority to waive grounds of inadmissibility under Section 212A conferred under any other provision of this Act shall apply equally to aliens seeking registered provisional status under this section. Subparagraph 2I, exceptions to that. The discretionary authority under Clause 1I may not be used to waive 1. Subparagraph B, C, D, little I, E, G, H, or I of Section 212A2. Then, subparagraph Roman numeral 2, Section 212A3, paragraph Roman numeral subsection 3, subparagraph A, C, D, or E of Section 212A10. So if I'm a United States Senator and I'm trying to protect the interests of the people of the United States, to understand what a piece of legislation means, I've got to go back and read every one of those subparagraph exceptions. This is gobbledygook. My staff tells me every time you go back and read it, you see more difficulties. I haven't even had a chance to look at this. And it's all through this piece of legislation. Oh, but don't worry about it. We've set up a vision. We've got a vision of this great immigration bill that's going to be comprehensive, fix all our problems. Trust us. Don't worry about it. You'll find out what's in it later, right? Just like health care, I guess. And this is not a way to do business. The immigration policy of the United States perhaps is as important as the health care policy of the United States. And I'm not going to consent to this. We're going to find out what's in it. It goes on more and more and more of this kind of gobbledygook. Subsection Roman numeral 4, with respect to misrepresentations relating to the application for registered provisional immigrant status, Section 212A6CI. And it goes on. Well, so it's not right to say that people who are concerned about the legislation are obstructing. We're trying to find out what the bill is. headline yesterday in the Christian Science Monitor said, how many people will be made legal under this bill? And they quoted one of the supporters of the bill as saying, we don't know. So I asked at the Judiciary Committee this morning, one of the sponsors was there, Senator Schumer. I said, well, how many people, you want to tell us, how many people are going to be legalized under the bill? We don't know. So we don't know that. We don't know answers to other questions like, how much will the bill cost the Treasury of the United States? What kind of expenses will be incurred? What is the total number of people that will be admitted? Well, what we have already discovered has revealed that the legislation fails to live up to virtually all the promises that have been made about it so far. I hate to say that, but that's true. For instance, and let me list a few. These are promises you've been told are taken care of or will be effectuated by the legislation if we just vote for this good bill. Just vote for it. It's 850 pages. Just vote for it. Here are some of the things. We were told the bill would be enforcement first, but the plan confers immediate legalization in exchange for promises in the future of enforcement, that many of which will likely never occur. I mean, we've got plain law now that requires removal in lots of cases that the Secretary is failing to follow. In fact, a major loophole that jeopardizes the entire border security section commands that the Secretary of HHS grant currently illegal immigrants permanent legal status and therefore a guaranteed path to eventual citizenship after 10 years if just one of the so-called triggers that are supposed to ensure that enforcement occurs is tied up by a court lawsuit. So all one has to do is to keep that tied up, and the people are not going to be deported if the enforcement doesn't occur. We were told the Secretary would be required to build the fence at the border. We passed a law in 2007 to require 700 miles of double-strength fencing at the border. Not the whole border, but 700 miles. How many has been built since then? 30. Congress passed a law that said we will do this enforcement in the future, but it hasn't occurred. We were told the bill would reduce the deficit. We've been told it will reduce the deficit and strengthen Social Security and Medicare. But it will be, the effect will be to legalize large numbers of low-skilled immigrants. Over half of those illegally here today don't have a high school diploma, and will add trillions to the unfunded liabilities of Medicare, Social Security, and the President's new Obamacare health care bill. We're talking about trillions of dollars when Social Security and Medicare need to be strengthened, not weakened. And the numbers are not going to be disputed on this. It is not going to strengthen Social Security and Medicare, as many advocates say. It's going to weaken them. And it's going to also weaken the financial stability of the Obamacare legislation. We're told illegal immigrants would not have access to public benefits, but the bill ensures that millions of illegal immigrants will immediately be eligible for state and local public assistance. If people need something, need health care, they're going to get it somewhere. And some can get formal benefits in as short as 5 years and will be eligible for all federal welfare programs at the time of the grant of citizenship. We were told there was a 10-year path to green cards or permanent legal residence and a 13-year path before you could become a citizen. But 2 to 3 million of those who are in the country legally are expected to assert that they came into the country as younger people and therefore would be eligible for citizenship in 5 years and would, under this remarkably broad DREAM Act provision that removes any age cap on the persons who can assert that they came as a youth, and even those who've been removed from the country can come back and claim the benefit of this. Illegal agriculture workers will also get green cards in 5 years. Legal permanent residents, if you're working illegally at an ag place today, a farm, you apparently would be able to get permanent legal status in just 5 years, and would enable them to be to receive benefits of some kind. We were told this legislation was for illegal immigrants who have deep roots in the country, but the amnesty is extended to recent arrivals, those that may have been here, came here as a single person just over a year ago. Millions would be legalized who've overstayed their visas. People who aren't even living in the country anymore could receive benefits and legal status, and those who have been deported multiple times, already been deported, could receive benefit under this. That's just what's in this complex 850-page bill. We were told the legislation would curtail the administration's aggressive undermining of federal law, that somehow the law is going to be enforced more. But it provides the Secretary of Homeland Security with even more discretion than she has today. It's filled with grants of waiver power and discretionary power. When the American people are very dubious of the willingness of our government to do anything that would consistently and effectively enforce law. And I believe the American people's heart is right about the issue of immigration. I believe the American people should be respected and their opinions valued. And what are they saying? They say we need a lawful system of immigration. People should be treated fairly. They believe in immigration. Right now we're bringing in 1 million people a year legally, and the American people say that's about right, although a recent poll just showed that over half of the American people believe that number is too high. They'd like to see it brought down some at this time of unemployment and falling wages. But they still favor strongly immigration for America, and they're not mad at immigrants, and they don't hate immigrants, and they don't dislike them. They respect people who want to come to America. They understand the desire of good people around the world who'd like to come to America. But what they're angry about is people in high office who flatly told them time and time again, we're going to fix this system, we're going to make it lawful, we'll make it one that you can be proud of, and then they don't do it. They say they're going to build a fence, and it doesn't get built. They say they've passed a law that requires removal of certain people who violate the law, and they don't get removed. And American people are right about this. It's Congress and the President that's not been fulfilling the right standards. We were told there would be strict standards for the amnesty, but the bill grants amnesty for those who've been convicted of multiple crimes, mostly nonviolent crimes, non-felonies, but it's a whole host of them. We were told the bill would make us safer, but Mr. Chris Crane, the head of the ICE Association, says it won't, that they've been undermined. They have voted, the 7,000-member association voted to no confidence in Mr. Joe Martin as supervisor. They filed a lawsuit, as I said, against the failure of their officials to allow them to enforce the law, basically complaining about their supervisors directing them to violate the law. That's what they complained about, and that's what the judge seemed to take very seriously. We were told that this would move us toward a merit-based, high-skill immigration system with a responsible future flow that would be more effective in identifying people who could be successful in America. This may be the biggest and most dangerous flaw of all. It does not look like it's going to move our numbers in any way in that direction. The bill would remove limitations on the number of visas for spouses and children of all green card holders, and that would apply to both those here illegally and all current and future legal immigrants. It would clear immediately, apparently, 4.5 million legal immigration backlog, people who filed to come under the chain migration, family migration. Only so many were supposed to be admitted per year, and you file and wait till your time comes up and then you get admitted. So apparently the drafters of the bill felt bad because people had said, well, you're giving people who came illegally advantage over those who have been waiting their time. So how did they solve that? That was a pretty brilliant way to solve it. They just agreed to let everybody who's filed come in immediately and wipe out all the caps. That solved the problem, all right. And those who approved under the DREAM Act as persons who came as younger individuals can obtain green cards expedited for their families, spouses, parents, spouses, and children. We've got to be careful that we don't create a system that allows aging parents to be brought to the country in large numbers that will be a burden on us. Truly, we've got to be thoughtful about that. We've got to be responsible. As a member of the Budget Committee, we're looking at these numbers, and we've got to reduce our costs, not add to it wherever possible. Agriculture Worker Program is expanded, giving the Secretary of Agriculture almost unchecked authority to increase these visas to whatever number he or she sees fit. And at a minimum, we're looking at handing out citizenships and green card. Think about this. How many will be here? The Christian Science Monitor asked. How many, I asked today in committee, to bill sponsors and supporters would be admitted over the next 10 years? Under current law, we should be admitting about 1 million people a year, the largest number any nation in the world allows to come into our country legally. That would be 10 million over 10 years. Under this bill, we believe the number will be 30 million plus. So, Mr. Chairman, I see my time, Mr. President, my time is up. I thank the opportunity to share these thoughts, and we're going to have to, I would ask consent to have one additional minute.
Without objection.
Just to say to my colleagues, I respect the work and their efforts, and I know that we are always valued immigration in our country, but it's time to create a system that serves the national interest, a lawful system where those who violate the law are validated, those who don't violate the law are not rewarded, a system that brings in the kind of persons that have the best chance to be successful and not be a ward of the state or charge on the state. And there are just a lot of things that we really need to do. Protect our national security, have a system and a policy that we're proud of that's morally defensible. I'm afraid this bill is not there, and that's why I'm concerned about it, and we'll look forward to doing the best I can to examine it carefully. Thank the Chair, and would yield the floor.
Mr. President. Senator from Iowa.
Over the course of the next several weeks, I hope to come to the floor and visit with my colleagues about the immigration bill that will soon be going through the Judiciary Committee. So I want to share my thoughts today on parts that deal with the border security section of S-44, 744. The immigration bill is very likely to allow millions of people who entered our country illegally or overstayed their visa to receive legal status and eventually green cards. However, it is very unlikely to result in a true border security. The bill provides that those in a probationary status, and that's known in this legislation as registered provisional immigrant status, be given green cards as soon as the Secretary of Homeland Security certifies that 4 conditions have been satisfied. On page 11 of the bill, it lays out the process. The Secretary certifies that the border and fencing strategies, and those strategies are ones that she wrote, are substantially deployed, operational, and completed. She also has to implement a mandatory employment verification program and the electronic exit system at air and seaports. The authors of the bill envision that this will happen in 5 or 10 years down the road. There are 3 reasons why this process is problematic. First, the Secretary has unbridled discretion to conclude that the 4 provisions have been satisfied, even if they have not been satisfied. The Secretary herself determines if the strategic plans are substantially deployed, operational, and completed according to the requirements of the law. For example, the Secretary could say that she is using an electronic exit system by collecting visa and passport information, even if that system is not totally effective. And the bill establishes no deadline for implementing any of these conditions. Second, the bar is set very low for certifying that these conditions have been met. One of the 4 triggers to green cards is the summation of a border fencing strategy. The bill defines in one sentence in Section 5 the contents of that border fencing strategy condition. At a hearing on Tuesday before our Judiciary Committee, Secretary Napolitano testified that fencing was not a priority of this administration. Considering how sensitive of an issue this is, you would not think that she would say that. She didn't really want $1.5 billion to be designated just for fencing. She implied that no more fencing was needed. Well, ask the people down on the border if that's true. She testified that the Department would prefer, quote-unquote, flexibility to use, quote-unquote, technologies other than fences. She stated that if she determined that little or no additional funding were necessary for fencing, that she might then be able to certify this condition very quickly. Third, litigation could ensure that legalization could occur in 10 years, regardless of whether any and all of the 4 border security triggers in the bill are met. The bill does this in 4 ways. First, green cards can be issued if litigation of any kind prevents any conditions from being met. Second, green cards can be issued if the Supreme Court rules that the implementation of any of the conditions is unconstitutional. Third, green cards can be issued if the Supreme Court grants review of litigation on the constitutionality of the implementation of these conditions. I note that this provision is especially ill-considered because it could trigger green cards merely because the Supreme Court agreed to review the conditions' constitutionality, a highly likely event even if the court later upheld them. Fourth, the bill restricts litigation challenging one particular decision of the Secretary to a constitutional challenge only. But that limitation expressly does not apply to litigation challenging implementation of the conditions. Litigation brought against the conditions can be based on any legal theory. Under the bill, if any court in this country issues a stay on implementing one of the conditions, then green cards are to be issued after 10 years. The bill does not specify what sort of ruling must prevent implementation, and even that the ruling be based on merits. Nor does the bill require that appeals run their course, even if the appeal upholds the condition. It says that the Secretary shall permit, and this is mandatory language, shall permit application for adjustment to the LPR status if litigation has prevented one of the conditions from being implemented. Under the plain language of the bill, 10 days after the day that any court prevents any of the border security conditions from being implemented, then, of course, the floodgates for green cards are to be opened. And nothing in the bill stops the administration from agreeing to a consent decree that prevents one of the conditions from being met. So, because I listened to 7 hours of testimony on Monday, and because on Tuesday the Secretary of Homeland Security shared her thoughts, I summarize to this one statement: not during all that time, not one person disputed the fact that legalization begins upon the mere submission of both a southern border security and fencing strategy. Thus, the undocumented become legal after the plans are submitted, despite the potential that the plans could be flawed or if they're inadequate. If enacted today, the bill would provide no pressure on this secretary or future secretaries to actually secure the border. Secretary Napolitano has stated that the border is stronger than ever before. She even indicated that Congress should not hold up legalization by adding border security measures and requiring them to be a trigger for the program. I'm concerned that the bill we will be taking up repeats the mistakes we made in 1986. And maybe people will resent my referring to 1986, but I do that because I went through this before, and we thought we were doing it in 1986 absolutely right. We didn't secure the border then and assumed legalization alone would stop the flow of more people crossing the border without papers. So simply, we screwed up. We need to learn a lesson, because the basis of this whole legislation is that the borders will be secured. The people don't want some phony language that allows the Secretary to circumvent congressional intent. So I urge my colleagues to really understand what the bill does in regard to border security, and in the process, to make sure the same mistakes of 1986 aren't repeated, insist that the border be secured instead of trusting what the Secretary says. Now, in regard to this whole issue, there's been lots of finger-pointing going on in Washington the past 2 weeks as it relates to immigration. It's a lot like the weeks and months after 9/11. What warning signs were missed about the brothers who bombed the Boston Marathon? Law enforcement and intelligence agencies tell conflicting stories. Bureaucracies are gearing up to do battle over who dropped the ball. They're preparing their defenses. They're leaking bits and pieces of information favorable to themselves. Meanwhile, Congress and the public have a growing number of questions. I have written the Department of Homeland Security and the FBI. Senator Paul and I have written on another matter to the FBI. But the Senate Judiciary Committee has not yet received clear answers to our questions. And there are very serious questions about whether our government has forgotten the lessons of 9/11. The most important of those lessons is this: when extreme fanatics say they want to wage war against us, we should take them seriously. Our government was reportedly warned on multiple occasions that one of these brothers had become a radical jihadist. Do we still have agencies failing to follow up, failing to share information, and failing to connect the dots? In this morning's Washington Post, the editorial board asked, quote, "Is the FBI focused enough on the real bad guys?" End of quote. Their editorial said that in addition to the older brothers in the Boston bombing, the editorial pointed out that in addition to the older brother in Boston, several people that have been investigated by the FBI have gone on to commit attacks. The Post cited two examples: the man who shot 2 soldiers at Little Rock Military Recruiting Office in 2009, and the man who is accused of shooting and killing 13 people at Fort Hood later that year. According to the editorial, quote, "Meanwhile, the FBI has devoted considerable resources to sting operations, sometime on what look like dubious grounds," end of quote. For example, the FBI launched an elaborate sting operation in Boston against a man plotting to attack the U.S. Capitol with a remote-controlled model airplane loaded with grenades, as the Post concluded, end quote, or begin quote. In some cases, it's not clear that a sometimes far-fetched plot would have gone forward without the encouragement and help of FBI informants, end of quote. Now, that's a very good point. It may be easier for an FBI informant to draw someone into a far-fetched plan, but it's harder to detect the real terrorist plot like the one in Boston. Unfortunately, it's connecting the dots that keep us safe, not those easy sting operations. Other warning signs about the older brother may have been missed because tips about him weren't shared between law enforcement. The older brother's best American friend was murdered in an unusual triple homicide. My office has been told local authorities investigating the murder were unaware of the warnings from Russia about his radicalization. Thus, those local authorities, in turn, apparently didn't know that they should make the FBI aware of the murder. 4 months later, the older brother traveled to Russia, just as the Russian government had warned us. The FBI claims that it was unaware of the older brother's trip, even though the Homeland Security Department says its systems alerted them to the travel. Did the Homeland Security Department fail to share the information with the FBI? The Immigration Reform Bill, with all of its bells and whistles, can't make agencies share information with each other. That bill is supposed to require background checks on 12 million people in our country undocumented. Yet it seems we have a hard time doing successful background checks just on those here legally. Lack of information sharing and failure to see real warning signs are probably things that no bill will fix. So what has to change is the culture. And of course, that begins at the top. It requires true leadership. At the end of the day, this is about much more than who dropped the ball. It's about learning from mistakes and doing a better job next time. In order to do that, we need real transparency about what happened, not just talking points from agencies trying to deflect the blame. The immigration bill before the Senate will make enforcement of immigration laws more inefficient, time-consuming, and ineffective. I'd refer my colleagues to Section 3502 of the bill. That section governs immigration court proceedings. Under current law, people here illegally who are going through removal proceedings are not entitled to legal counsel at government expense, and the Justice Department is not required to provide them. However, this section opens the law wide open, making taxpayers foot the bill for attorneys who will represent people here who are undocumented. It provides that, quote, the Attorney General, in the Attorney General's sole and unreviewable discretion, may appoint or provide counsel to aliens in removal proceedings, end of quote. The heading of the section implies that court proceedings would run more efficiently when in actuality the goal is to ensure that people here illegally have every opportunity to fight removal orders. Some of these aliens could be dangerous. They certainly don't deserve free counsel when the Attorney General is inclined. Making it harder to deport aliens who should be deported will make it harder to deter aliens from entering the country illegally. Of course, there are organizations such as law firms, law school clinics, and others who provide pro bono legal services to aliens at no cost to the taxpayers. But the bill's language is just so astounding. There are very few statutes that say that any government official can do anything in his or her sole and unreviewable discretion. That means no oversight. But time and again, throughout this bill, this language pops up. It means that no court can stop what that official wants to do. That's hard to square with our principles of a democracy. And this government, based on the principles of checks and balances. Ironically, the title of the section implies that this measure would, quote unquote, reduce costs. But in fact, it only increases costs to the taxpayers. This measure, to provide legal counsel for people here illegally, would be paid for from the newly created fund known as a Comprehensive Immigration Reform and Trust Fund. This fund, on the date of enactment, will have $6.5 billion, which is transferred from the General Treasury. How much will this section cost? We don't know until CBO scores it, but it won't be borne by the people in the removal proceedings, and that's going to be hard for the American people to swallow. Anything that makes deportation harder and that makes deportation proceedings more likely to be about delaying tactics should be avoided. But the immigration bill appears to desire those results as goals. We should decline that invitation to mischief that's going to be a direct result. Mr. President, on another matter, I have long been a strong advocate for responsible stewardship of the taxpayers' dollars. Throughout my career, I've sent countless requests, letters, and conducted numerous investigations, all in the interest of preventing waste, fraud, and abuse of the taxpayers' money. Today, we're confronted with the government that is recklessly spending tax dollars and running up a huge federal budget deficit and debt. We're also confronted with the need to tighten the government's belt when it comes to this reckless spending. One area where we need to do a better job of responsibly using taxpayer dollars is through our drug treatment and prevention efforts. I have a strong commitment to ensure drug abuse does not flourish in communities throughout the country. I have championed numerous efforts to prevent drug abuse before it starts, and that includes my sponsorship of the Drug-Free Communities Grant Program. Drug abuse is very costly to society. The National Survey on Drug Use and Health estimates that 22.5 million Americans aged 12 and older used drugs in 2011. This is clearly a problem that needs to be addressed in an aggressive and wise manner. Senator Feinstein and I requested the Government Accountability Office to conduct a study of the federal drug treatment and prevention programs that has recently been released. This report and another which is annually reported It reports on the duplication and overlapping of federal programs, states that out of 76 drug abuse prevention and treatment programs, 59 or nearly 80% had evidence of overlapping efforts. In fiscal year 2012, $4.5 billion tax dollars were allocated to these programs. The Government Accountability Office reported that some programs, including the Drug-Free Communities program, have a low risk for duplication because they have coordinated their efforts among their respective administering agencies. However, 29 of the 76 programs surveyed reported no staff having coordinated with other agencies or programs to reduce duplication. Now, this is almost 40% of all federal drug prevention and treatment programs. The report further states that the Office of National Drug Control Policy, which is responsible for coordinating the government's anti-drug efforts, has not systematically assessed drug abuse prevention and treating programs to examine the extent of overlap and opportunities for coordination. It is with disappointment that I learned that the President has proposed a significant increase in his budget to many of these programs. Specifically, the President has proposed a $1.5 billion increase in drug treatment programs, which is an increase of 18% from fiscal year 2012. Many of these programs have good intentions and may even do good work. But in a time like now, when we're making many painful cuts throughout most government agencies and programs, in order to rein in spending, should we then be making such large increases? Further, should we be spending more taxpayer dollars on programs that are duplicating efforts before they correct their problems? The last thing that we need to be doing now is chasing good money after bad, and this is what, in this area of the President's budget, he's proposing to do. Before we start increasing any program budgets, we must first ensure that program is responsibly tracking and utilizing every taxpayer dollar it currently has and not wasting it by duplicating the work of another program. One example of success in eliminating duplication can be found with the National Drug Intelligence Center. This center had repeatedly been listed as a duplicating agency for a number of years. The funding for this center was eventually eliminated in fiscal year 2011, while the work of the center has been consolidated. I'm pleased that the Office of National Drug Control Policy agrees with the government recommendations of the Government Accountability Office's report to assess the extent of overlap and duplication across all drug prevention and treatment programs by identifying where agencies can better coordinate their efforts.
Mr. President?
Yet,
Majority Leader.
Could I ask my friend to yield for a unanimous consent request?
I've got 15 seconds left. Is that okay?
Of course.
Okay, thank you. Yet these actions should have been taken years ago. So it's very disappointing that we have this report now. It needs to be put into effect. I think the Government Accountability Office did good, and I'll put the rest of the statement in the record. I yield the floor.
Mr. President,
The Majority Leader.
I ask that the Senator's statement not appear interrupted in the record.
Without objection.
I ask unanimous consent that the vote on the motion to invoke cloture on S-743 occur this evening at 5:35 p.m. Further, that if cloture is invoked, all post-cloture time be considered expired at 5 p.m. Monday, May 6th. The Durbin Amendment number 745 then be withdrawn. That no other second-degree amendments be in order. That the Senate then proceed to vote in relation to the NZ Durbin Amendment number 741. That upon disposition of the amendment, the Senate proceed to vote on passage of the bill as amended. If amended, finally, that the filing deadline for second-degree amendments be 4 p.m. Monday, May 6th. Mr. President, just briefly, I appreciate very much. This is a consent agreement that I had nothing to do with, and I appreciate all the good work of everyone that's been involved in this.
Is there any objection to the request? Without objection.
I don't want to yield in any way.
clerk will report the motion to invoke cloture.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on S-743, a bill to restore states' sovereign rights to enforce state and local sales and use tax laws and for other purposes, signed by 17 senators.
By unanimous consent, the mandatory quorum call has been waived. The question is it the sense of the Senate that debate on Senate 743, a bill to restore states' sovereign rights to enforce state and local sales and use tax laws and for other purposes shall be brought to a close? The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Alexander, Ms. Ayotte. Ms. Baldwin. Mr. Barrasso. Mr. Begich. Mr. Bennett. Mr. Blumenthal. Mr. Blunt. Mr. Bozeman. Mrs. Boxer. Mr. Brown. Mr. Burr. Ms. Cantwell. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Chambliss. Mr. Coates. Mr. Coburn. Mr. Cochran. Ms. Collins. Mr. Coons. Mr. Corker. Mr. Cornyn. Mr. Cowan. Mr. Crapo. Mr. Cruz. Mr. Donnelly. Mr. Durbin. Mr. Enzi. Mr. Enzi. Mrs. Feinstein. Mrs. Fisher. Mr. Flake. Mr. Franken. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mrs. Hagan. Mr. Harkin. Mr. Hatch. Mr. Heinrich. Ms. Heitkamp. Mr. Heller. Ms. Hirono. Mr. Hoven. Mr. Inhofe. Mr. Isaacson. Mr. Johans. Mr. Johnson of Wisconsin. Mr. Johnson of South Dakota. Mr. Kane. Mr. King. Mr. Kirk. Ms. Klobuchar. Ms. Landrieu. Mr. Lautenberg. Mr. Leahy. Mr. Lee. Mr. Levin. Mr. Manchin. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Ms. Mikulski. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Nelson. Mr. Paul. Mr. Portman. Mr. Pryor. Mr. Reed of Rhode Island. Mr. Reed of Nevada. Mr. Risch. Mr. Roberts. Mr. Rockefeller. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schumer. Mr. Scott. Mr. Sessions.
Roberts, I need to see you in Sessions.
Mrs. Shaheen.
I'm going to vote no. Thank you.
Mr. Shelby. Ms. Stabenow. Mr. Tester.
No, it was in the paper. Today? Yeah. Mary?
Mr. Thune. Mr. Toomey. Mr. Udall of Colorado. Mr. Udall of New Mexico. Mr. Vitter. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Senators voting in the affirmative: Baldwin, Bennett, Blumenthal, Cardin, Carper, Chambliss, Cochran, Coons, Cowan, Donnelly, Durbin, Enzi, Fisher, Franken, Hagan, Harkin, Heinrich, Heitkamp, Johans, Johnson of South Dakota, Kane, King, Klobuchar, Landrieu, Leahy, Manchin, Menendez, Mikulski, Murray, Nelson, Pryor, Reed of Rhode Island, Reed of Nevada, Schatz, Udall of New Mexico, Whitehouse. Senators voting in the negative: Ayotte, Barrasso, Coburn, Crapo, Grassley, McConnell, Merkley, Murkowski, Hall, Risch, Roberts, Rubio, Tester, Thune, Wyden. Mrs. Shaheen, no. Mr. Brown, aye. Mr. McCain, aye. Mr. Bozeman, aye. Mr. Sanders, aye. Mr. Scott, no. Mr. Graham, aye. Mr. Hatch, no. Mr. Kirk, no. Mr. Coates, no. Ms. Cantwell, aye. Mrs. Gillibrand, aye. Mr. Inhofe, no. Ms. Stabenow, aye. Mr. Burr, no. Mr. Sessions, no. Mr. Chambliss, no. Ms. Collins, aye. Mr. Murphy, aye. Mr. Lee, no. Mr. Moran, aye. Ms. Warren, aye. Mr. Casey, aye. Mr. Begich, aye. Mr. Corker, aye. Mr. Shelby, aye. Mr. Warner, aye. Mr. Levin, aye. Mr. Schumer. Mr. Schumer. Aye. Mrs. Feinstein. Mrs. Feinstein. Aye. Mr. Isaacson. Mr. Isaacson. Aye. Mr. Heller. Mr. Heller. No. Mr. Baucus. Mr. Baucus. No. Mr. Toomey. Mr. Toomey. No. Mr. Blunt. Mr. Blunt. Aye. Mr. Udall. Mr. Udall of Colorado. Aye. Mr. Rockefeller. Mr. Rockefeller. Aye. Mrs. McCaskill. Mrs. McCaskill. Aye. Mr. Johnson. Mr. Johnson of Wisconsin. No. Mr. Hoeven. Mr. Hoeven. No.